2001. And we're going to talk about the legal issues today and some of those things that are coming up. Always the disclaimer, as you know, this presentation is intended to be educational. It's not a platform where I can give you specific legal advice. And while you're welcome to ask questions, if it's something that's a pressing or a legal issue you're dealing with presently, we need to deal with that in a different place, not online with everyone else involved. Also, you should have received from MSSOA, and this will be backwards, I think, you should have received a handout that came by email. It looks like this. The information I put on the screen today is going to track what's in that handout, but will not match it identically. So you may want to have that out and available as we go through things today. Much of the information I'm going to cover is frankly information you've probably heard me go over before, but I want to approach it from a little bit different standpoint. From a trend that I'm seeing where problems arise, and that problem is where current technology meets the law. And that's kind of the way I want to approach this. Today. So back in 2001, 2002, when I first went to work for Missouri Self-Storage Owners Association, my first project was to create a carbonless form model rental agreement. And this was the cutting edge of technology at the time because you could have a tenant sign this document and you immediately had two signed copies, one for your file, one for their file, and we just thought we had hit the mother lode. We just thought we had it made, but things change. All of a sudden, we transitioned into a world of computers and internet and digital business and all kinds of things, and it revolutionized our world, including self-storage, so that now you have the option of paperless transactions, software to manage everything involved with your business, including rental agreements and lien sale procedures. A lot has changed. In fact, Steve was just telling us about many of those things, and it's very much for the good. These are incredible tools that are available for you to manage and become more efficient in your self-storage business. I'm all for them. But here's what you have to know. With all that technology, the Missouri Self-Storage Facilities Act has not changed dramatically since 1985. It predates all of those technological advancements that we were talking about. What you see on your screen there is a photocopy of what that statute looks like in the dusty law books on my shelf. But here's the thing, it still applies. We've had some updates that pay homage to the digital age, where we can now send notices by email, we can use online auctions, those kinds of things. But essentially, the law that governs your business in Missouri has not changed since the days of the carbonless form contract. And so that's what you've got to be aware of. So why is that important? Let me go back here. Why is that important? Well, because if you're doing business in Missouri, you must follow Missouri law. Following California law doesn't help you. Following Kansas law doesn't help you. If you're located in Missouri, you've got to follow Missouri law. Following from that, no matter how advanced your technology gets, you still have to comply with that Missouri law. Even though you're trying to apply a 20th century statute to a 21st century digital business platform, it still applies. And the failure to comply with that law, whether you have an electronic platform or otherwise, failure to comply with it leads to bad results. Why? Because to have a lien and a lien sale and be able to take advantage of that, those laws are strictly construed in Missouri. What does that mean? That's just lawyer talk for you have to follow the rules by the book. And if you fail to do so, you have no lien. Whether you're doing business electronically or otherwise, you have no lien. And if you sell that property anyway, bad things will happen. So if you fail to comply with Missouri law, you lose a quick means of getting a delinquent tenant out of a unit and putting it back into productive service so you can earn more rent again. You lose that. If you don't follow Missouri law, you lose an opportunity from a lien sale to recoup at least some of what money you're owed by selling the property in the unit. You lose that. If you don't follow the law, you also have no right to sell. And if you don't follow the law and you sell anyway, you open yourself up to damages and you open yourself up to punitive damages for wrongdoing. And I will tell you, that's an uncomfortable place to be, because if you sell somebody's property without the right to do it, you basically stand from a legal perspective naked before the court. You have nothing to argue about except possibly the stuff I wrongfully sold wasn't worth as much as the plaintiff now claims. So please understand, you've got to follow those rules, even if it's electronically. So as a result, much of the available technology nowadays comes with one of these. It's a disclaimer. And it basically says, any sample forms or contracts that come out of this software are examples only. Please check with your state self-storage association as to the legal and proper content of any forms or contracts you use with your business operations. We disclaim any representations or warranties as to the legal or factual accuracies of these sample forms or contracts. Well, now that is classic lawyer language. What does it really mean in practice in English? It means this: there is no guarantee this software complies with Missouri law. And if you use this software without making sure it complies with Missouri law, you alone are responsible for the consequences. In other words, just because it comes spitting out of your computer, software generated, does not mean it complies with Missouri law. Okay, that's what those disclaimers mean. You can't afford to ignore that, because for software companies, for technology companies, they're selling a product across the country with laws that differ in all 50 states. So they, by definition, have to sell a one-size-fits-all type of product. And they know this. That's why they're warning you with that disclaimer that you need to be aware of what you're doing here. Most of that software, all of it, I believe, comes with some customizing features that you will use to make sure what comes out of that computer, what's being done with that by your software technology, it complies with Missouri law. Why is this important? Because we know you have to follow Missouri law. Even in the 21st century, using a digital platform, electronic platform, you still got to comply with it. And if you don't, we know bad stuff happens. So you cannot rely on the technology to ensure that you comply with Missouri law. Many of you may remember Smokey the Bear, when we were kids, warning us that only you can prevent forest fires. Well, please think of me as Stanley the Bear telling you only you can comply with Missouri law. Your software provider isn't going to do it, can't do it in all likelihood. It's not even the job of the Missouri Self-Storage Owners Association. You have got to make sure that you get the resources in place to make sure that your system is complying with Missouri law. Well, it all starts with the right rental agreement. Because to have a valid lien in Missouri self-storage lien, you've got to have the correct rental agreement with your tenant. I put in your handouts that you received by email a handout called "Does My Rental Agreement Comply with State Law?" That document is intended for you to lay next to your rental agreement and just match them up. There's a section there that talks about things that must be in your contract. There's also a section that talks about things that are a good idea but are not legally required to be in your contract. Match them up. And if you find something on that document that's not in your contract, you may have an issue, and you should talk to somebody who can give you some legal advice regarding the adequacy of your contract. Now, I'm not going to go through everything in that handout, but let me just tell you some of the major ones I tend to see when contracts, rental agreements for self-storage pass my desk. First, Missouri law is clear. Your rental agreement must be signed by the operator and by the occupant. Okay. If it's not, you can have the best rental agreement in the whole wide world, one that should be cast in bronze and put on a marble plaque someplace. But if it's not signed, it's no good and does you no good at all. And again, you're left standing naked before the court. So make sure that contract is signed by the operator, that's you, and by the tenant. Also, it's best if you can keep in your file a copy that is signed by both. I see some people who will have the tenant sign one, but they don't get around to signing one for their file. Make sure you put both of them in there. Also, and this is something that I recently became aware of, it's best if your terms and conditions are part of the document that are being signed by the tenant. Don't separate a signature page from the terms and conditions of the contract. I'm aware of a case recently where an operator did that, and the judge concluded that the occupant or the tenant never actually saw the terms and conditions, and therefore they didn't apply. So you basically had whatever few terms, scant terms, were on that rental agreement signature page and nothing else. And, wouldn't you know it, the critical things about the lien and such as that weren't on that signed page. And that's where a judge, you need to have those things together. I've seen people who put only the signature page in files and leave the terms and conditions taped to the counter. I think that's a bad practice, because I think you're running the risk of a court saying, I'm sorry, there's no proof here that what the client or what the tenant signed included all of these terms and conditions. So keep it all together, if you will. The other thing that I see commonly is the failure to meet up with the requirement that says the information about our self-storage lien must be in boldface type. I don't understand this. For 25 years, I've been preaching this message, and it still occurs. Nothing could be simpler. You don't have to have a law degree. Is my operator's lien information in bold type? And if it's not, your rental agreement doesn't comply with the law, and you give an angry tenant whose property you've sold a reason to sue you based on that alone. They can argue you didn't follow the law, therefore you didn't have a lien, therefore you didn't have the right to sell my stuff, and now I'm going to stick you for it. So please just make sure it's in boldface type, not in all caps, not underlined, not in bigger font, in boldface type. Just stay close to what the statute tells you and you'll be fine. And of course, that boldface language must tell people there is a lien on stored property. It can be sold if you're in default, that you'll hold the excess for a while, but after a year, it goes on to the state treasurer. So make sure you have that information there. Also, remember, if you want to charge a late fee, it must be either in your rental agreement or in an addendum to the rental agreement. I hear people say, yes, I charge a late fee, but it's just posted on the wall. Not good enough. Has to be in the rental agreement or in an addendum to the rental agreement if you're going to charge that late fee. Some good news about rental agreements, I don't want to make it all sound bad, is they can be electronic in format, as can the signatures. And we're going to come to that a little bit later, but since we're talking about technology, that's a good thing. Missouri law, federal law is clear. These things can be done electronically. Well, unfortunately, you can have the best lien sale or the best rental agreement in the whole world, but sometimes you run into tenants who simply don't pay. And you have a number of options in that regard. The one we'll focus the most on today is a lien sale, but some of those other options are, if you had a tenant who wasn't paying, you could always terminate the contract, make them get out. You also would always have the right to go down and sue them without terminating the rental agreement, and sue them for whatever amount of money you're going to get or whatever amount you're owed, but that's a slow, cumbersome, and often expensive process. You also, if it's a vehicle or a watercraft and the rent has not been paid for 60 days, you can have that that vehicle or watercraft towed from your unit, or your facility, so you can put it back in productive service. So that's an option. And if it's a unit that has nothing of commercial value in it, reasonable commercial value, then you can otherwise dispose of it. It can go to the dumpster. It could go to Goodwill. It could go whatever you want to do with it at that point if it has no reasonable commercial value. But usually what's going to happen is when you go into a default, is you're going to have a lien sale. And here's what you have to remember about a lien sale, okay? That lien sale has a specific process and it must be followed. There's a specific process and it must be followed. Now, in your handout that you received by email, there's a document called the Missouri Lien Sale Timeline. That one gives you more detail than we're going to cover on the screen today, but you may want to look through that. That becomes your roadmap. If you have a tenant who goes into default, that is your roadmap, not what necessarily comes spitting out of your computer at any particular point in time, okay? What comes out of that computer may comply with Missouri law or it may not. But remember Stanley the Bear telling you only you can comply with Missouri law. You're the one who's going to have to make sure that what's being sent, what's being said, when it goes, that those things comply with Missouri law, because your software vendor most likely is not in a position to ensure those things, and thus the disclaimers we saw before. So let's talk about the process. As I said, in that lien sale timeline, you'll have it in a lot more detail than I'm going to have on the screen, but you can track along. You can certainly track along with it. So really, oversimplified, there are really 5 steps to this. Now let's stop there. If you're using some sort of electronic or some sort of technology, you're using software that manages this for you, take a look at those 5 things on the screen. If your software is doing something that is less than that, then you may have a problem with Missouri law. If you look at that list and you say, my computer software process has a lot more steps than that, then you may be doing more than the law is requiring. It may be costing you more money, maybe not, and it may or may not make you in compliance with Missouri law. So again, this is where you've got to be really careful, because in my experience, if an angry tenant whose property has been sold in a lien sale wants to make trouble, it will either be because the rental agreement did not have the right language in it, or it will be for some reason you failed to follow this procedure. So it all begins with a default. And that simply means the tenant fails to do something on time that he or she is supposed to do. Normally, that's going to be they failed to pay rent. Now, you have a number of things you can do at that moment. You can lock that person out the moment they're in default. Now, when does this default occur? Well, default occurs one tick after, by the clock, after the rent was due. So if rent was due on the 1st, then a tenant is in default at at midnight plus 1 second on the 2nd. They are now in default. At that moment, you can deny access to that tenant's unit. And you do that, of course, to protect whatever may be in the unit from being spirited away in the middle of the night before you can have your lien sale. So that's the default. It all begins with a default. If you don't have a default, none of this process goes into play. If the unit is paid up, you probably don't have any, you have to look at other alternative remedies if you've got a problem with a tenant, but a lien sale is not going to be one of them. Now, in my opinion, as a business matter, you send, as soon as possible after that default, you send the first default letter. Now, there's no magic to when that first default letter must go. Some people, like I said, if it's due on the 1st, they send it on the 2nd. Other people wait 5 or 6 days. It's entirely up to you. And incidentally, that has the day of the default has nothing to do with a late fee. It has nothing to do with anything like that. Now, if you have what's called a grace period, where you tell people, I won't consider your rent late for 5 days after the due date, well, then you can't declare a default until you get to day 6. But generally speaking, if rent is due on a particular date certain, the tenant is in default the next day. And that has nothing to do with when you charge a late fee, two separate things. So you send that first default letter. That first default letter is the nice letter. That's just the very friendly reminder that your rent was owed, we haven't gotten a check from you, or we haven't had a payment from you, and you really need to take care of this. That letter goes by regular mail or by email, and it goes to the tenant, and it goes to any lien holders who've been disclosed to you. So if the tenant stores something and somebody else claims a lien in it besides you, and they've told you about it, then you have to send that notice to them as well. Or a third party owner. What in the world is that? Well, that would be a situation that arises where a tenant of yours has stored something that belongs to somebody else. If they've disclosed that to you, then you also need to send that first notice of default to that third party owner. Now, if they have not disclosed these things to you, you don't have any duty to send the notices to those parties. Now, after you send that first notice of default, you need to wait 10 days or more, 10 days or more, or more than 10 days, excuse me, and send the second default letter. Now, if there's anything in this process where the problems will arise, it will arise with this second default letter. Why? Because Missouri law is very specific about what has to be in that letter. Now let's stop here. Going back to technology, I find that many of these software providers will spit out of the computer a second default letter, but unless they have been tailored with the specific requirements of Missouri law, they oftentimes don't contain the information that Missouri says must be in there. So that's why you've got to be really, really careful and make sure these things line up. So what needs to be in there? Well, first of all, let me just say this. This letter goes by verified mail, which simply means some means of sending it where you have proof of mailing, not proof of receipt. This is not certified mail with return receipt requested. All you have to have is proof that it was mailed, and that's called verified mail at the post office. Or you can send it by a private courier if you want to, or it can be sent by email, which is of course much easier and simpler. This one goes to the tenant, and it also goes to any disclosed lien holders. For whatever reason, the legislature, when we made our last amendments to this act, did not require this second notice to go to third-party owners. So it just goes to the tenant and any disclosed lien holders. What has to be in the letter? You must tell the tenant that the stored property is subject to your self-storage lien. You also must tell them the amount that is due presently. The day you sign the letter, what do they owe you? You also must tell them the amount of the charges that'll be due before the sale occurs and when those will become due. So, as you know, in Missouri, you can't have a lien sale until 45 days have elapsed. Well, another month of rent is going to come due. Well, you need to tell them in that letter, rent will be due as always on the 1st in the amount of whatever that is. A late fee will be charged on the 7th day thereafter and whatever amount that is. But you've got to spell that out in the letter. You make a demand for payment on a date that is at least 10 days after the date you mail the letter. So you've got to give the tenant 10 days after you mail the letter to come in and pay. And the letter also must say that unless that is paid, the stored goods will be released for sale after a specified date. Okay? Now that word after in there is very important. You want to tell them there will be a sale after a date and not the specific date of the sale, because if you have to change that sale date, the freak snowstorm comes in, whatever it might be, then you have the flexibility to reschedule your sale without having to send this second notice of default again. So make sure you pick that date and say you'll be sold after a specified date. And then you need to tell them where and how the tenant can contact the operator. Why is that important? Well, because, as you'll recall, a tenant who's in default has the right to redeem their property from sale at any time up until the property is sold. So they need to be able to know how to find you. So that's your second default letter. That's the one where the problems arise. That's the one where you cannot just rely on what's coming out of your computer from your software vendor. It may be right, it may not be right. You're the only one who can make sure that it is. So please keep that in mind. Now, 7 days before the sale, you publish an ad. The ad is published once, at least 7 days before the sale, in the classified section of a newspaper of general circulation where the sale is to be held. That's a mouthful, okay? So basically, that ad gets published once. I have seen people who publish an ad every week for 4 weeks prior to the sale. There's absolutely no reason to do that. And when I asked why they were doing that, they said, well, that's what the computer tells me to do. Well, I'm sorry, that doesn't comply with Missouri law, and you're wasting money and time because you don't have to run it that many times. One time, at least 7 days before the sale. It has to be in a newspaper of general circulation where the sale is to be held. Keep in mind, you do not actually have to have a lien sale on your property. You can do it in other places. If you choose to do that, and you were to cross a county line, for example, you would need to publish the ad where the sale is to occur, not where your facility is necessarily located. Then you come to the lien sale. That can be public or private. Public, we're typically thinking of an auction where people bid. Private can be other arrangements for sale. Both are fine. The terms are cash, but it must be commercially reasonable. And that simply means, are you selling goods in a way that a merchant of those types of goods would normally sell them? And usually most things can be auctioned, so that's what that means. Is it reasonable and fair? And it must be no sooner than 45 days after you send the first default letter. I often hear people say you can't have a sale until 45 days after the tenant is in default. That's technically not what the law says in Missouri. Missouri law says it can be no sooner than 45 days after step 2 on this slide, after you send the first default letter. So that may be yet another good reason not to delay between the time of the default and when you send that first letter, because the longer you delay that lien sale on the other end. So that's your procedure. Again, your site management software may prepare these documents and automatically schedule their delivery and send them out, but they've got to comply with Missouri law. And otherwise, they are useless, and you open yourself up to incredible potential liability. So please make sure that these things are comply with the law. Now, I told you you've got a 20th century statute that's being applied to a 21st century business model. It gets worse than that. In one aspect of this process for a lien sale, you're actually using 18th century technology as part of your 21st century business model, and that has to do with an advertisement. And the question, where do I advertise the sale of this paper? Well, or this sale rather, where do I advertise? Here's an example of one that I just clipped out of the paper just earlier this week, and this one is well done. Although this one is over on the Kansas side of Kansas City, but nevertheless, it meets the requirements of Kansas law. So the first thing you need to know about the ad is, according to Missouri law, you must publish an ad. There are no exceptions. Let me say that again. In Missouri, if you're going to have a self-storage lien sale, you must publish an ad in a newspaper of general circulation, and there are no exceptions. I hear that, I get this all the time. I hear people say, well, I'm doing everything electronically. And I have to say, I'm sorry, you still have to publish an ad in a newspaper. Well, I'm using an online auction service. They put the notice on their website, et cetera, et cetera. And I have to say, well, that's great, but you still have to publish an ad in a newspaper. Or they say, well, I'm not going to have an auction. I'm just going to have a private sale to a local merchant. And I have to say, well, that's great. You're entitled to do that, but you still have to publish an ad before the sale occurs. So there are no exceptions. And let's make sure that's clear. You have to publish an ad. Where to publish the ad? By the way, there is in your handout a page on this, where to publish my ad, and I'm going to be talking about some of those issues, but you're welcome to follow along there. As I said, it has to be where the sale occurs, and it has to be in a newspaper of general circulation in the jurisdiction where the sale is going to be held. Jurisdiction there typically means city or county, is usually what we think of that meaning. And general circulation doesn't mean that the newspaper has to be published in your county. It just means to say it generally has readers in your county. So for example, my office is in the city of North Kansas City in Clay County, Missouri. The Venerable Kansas City Star is published in Kansas City, Missouri, in Jackson County, Missouri. Well, we could, if I had a self-storage facility instead of a law office in North Kansas City, I could use the Kansas City Star to publish my lien sale ad. Why? Because even though the Kansas City Star is not published in North Kansas City, there are lots of people who read it here. It would qualify as being in general circulation in the jurisdiction where I'm going to hold the sale. So I know in some counties, some cities, you may not actually have a local newspaper anymore. They're becoming fewer and fewer. So again, what you're looking for is something that generally has a readership and subscribers in the area where you're going to have the sale. Then understand you have to publish it in a newspaper. A newspaper means that it must have news. Okay, it can't be just some sort of a sheet that does nothing but publish legal notices. I don't think that qualifies under Missouri law. It needs to have news articles of general interest to the population. That's what it means by a newspaper. It must publish at least once per week. So if it's some sort of bi-weekly publication, won't work. Has to be published once a week. It has to be delivered as a periodical by the post office. In other words, it's not some sort of newsletter that goes in an envelope that's mailed, to specific people. It's a general publication, and that's the way it's treated by the post office. The newspaper must have been in business and publishing for at least 3 years, so you can't use some startup on the corner. It's going to have to be an established newspaper, and it has to have paid subscribers, okay? So I sometimes get the question, can I just advertise in the local shopper? The answer is no. Why? First, because it's not a newspaper typically, it just has ads. And second of all, it doesn't have a paid subscription. It's just something they stick in your mailbox. So that won't work. It's got to have a paid subscription. Now, there are some special rules for newspapers. If you're in a city of over 100,000 people, there are some rules regarding daily papers there. And if you're in a first-class county, and those are listed for you in the handout, there may be certain designated papers that must be used. Here's the fail-safe. If you still don't know where to publish, call the courthouse in your jurisdiction, in your county, or if you're in the city of St. Louis, the courthouse there. Ask for the circuit clerk or ask for the clerk of the probate court. Both of those offices have to publish a lot of notices, legal notices, foreclosure notices. There are some published or that get filed. There may be change of name judgments. There may be all kinds of probate notices. Ask them where they publish the legal notices that are required for your county. And you shouldn't go wrong if you publish your notice in that same newspaper. Okay, so that's kind of a fail-safe. If you can't figure it out, that's where you go. And there may be more than one that qualifies in your jurisdiction. If that's the case, I'd suggest you use the cheapest one and go from there. So that's the basic of publishing and where to publish. You're looking for a newspaper of general circulation in the county where the sale is to be had, and you're looking for a genuine newspaper and one that's established. So that's the way that works. Now, the next issue that Steve was talking about, and I've been alluding to it as well, and that's all about electronic rental agreements and signatures and the technology. My goodness, you can do this stuff on your phone nowadays. Remember, all of that Missouri law relating to self-storage still applies. So let's talk a little bit about electronic contracts, rental agreements and signatures in Missouri. There's also a handout or a page in your handout dealing with this that'll go into a little bit more detail. As I mentioned before, the good news is that electronic contracts and signatures in Missouri and in federal law are valid and enforceable. No question about that. They are valid and enforceable. So that's great. We can do business that way. But there are some potential pitfalls that you need to be aware of under Missouri law dealing with electronic contracts and signatures. And you'll see those listed on that handout that I mentioned to you. Well, what are some of those? Well, first of all, under Missouri law, an electronic contract like this to be formed must be formed by agreement. In essence, in other words, you cannot force somebody to enter into an electronic contract against their will, nor can a tenant force you to do that if you don't want to. So it's got to be by agreement. Also, an electronic rental agreement is not enforceable unless the tenant can print or store the rental agreement. So the moment that rental agreement, electronic rental agreement, is signed and is in force, that tenant must be able to either pull up that document as something they have stored on their electronic device, or they must be able to print it off. And if they can't, then your contract is voidable in Missouri, meaning it has no force and effect. So make sure that your whatever system you're using will allow them to do that. Keep in mind, you may have to prove that the person whose electronic signature went on a contract is the person who it appears to be. In other words, how do you deal with the tenant or the person who says, well, yes, that's my name, but I didn't enter into this contract? Well, you're going to have, if you want to enforce the contract, you're going to have to be able to prove that the person is who they say they are. Now, the statute gives you a lot of variety of ways to do that, and your software may have ways to make that abundantly clear. But understand that's a potential risk, and you're going to have to be prepared to enforce that or to deal with that if you want to enforce the contract. You must give the tenant an opportunity to correct any errors before he submits his agreement, or he can void the contract. So in other words, if he makes a mistake and realizes it before he enters the contract, you have to make a means available for him or her to go back in the sequence and correct whatever was wrong before he or she hits the button, does the electronic signature, and enters the contract. If you don't, then the tenant can void that contract. And where that might come up of interest to us is if the tenant knew, for example, that they had gotten their last known address in the contract incorrectly, knew it, but couldn't find a way to get back to it and fix it, and hit enter or signed the contract and submitted it anyway. If you send those notices to the wrong address, the tenant can simply say, well, I'm sorry, I didn't get a chance to fix it before I entered it. And as a result, shouldn't be binding. And Missouri law would say, yes, Mr. Tenant, you're right about that. So make sure there is that ability to fix something that's incorrect before the tenant actually submits the contract. Finally, the tenant must have the opportunity to either proceed or abort the contract process, and he must know that if he proceeds, the rental agreement will be completed. there has to be that moment of truth where the tenant is made to understand by clicking below, by signing your name below, whatever it may be, okay, you understand you are forming a valid contract. And if you don't give that tenant that moment of truth, then arguably he can void the contract. So those are some of the pitfalls. I suspect most of the software you're dealing with is sophisticated enough to help you deal with those issues, probably because this law in Missouri is similar to laws across the country and to federal law. So it's probably going to help you with that. But again, you need to make sure that those things are done. And keep in mind, Missouri self-storage law still applies to that electronic contract. Which means, even though it's electronic and you may be able to use electronic signatures, it needs to have a signature by the operator and by the occupant. It must include language required for the operator's lien, and it must be in boldface language, boldface type. So whatever your tenant is seeing on the screen where he or she is entering into a contract electronically, that operator's lien had better be in boldface language, or you're going to be in trouble. And that should also be true, of course, in whatever they're printing out or storing. Keep in mind, too, that another thing we typically put in these contracts are what we call exculpatory clauses. These are the clauses we put in a contract in order to limit your liability. They may be releases that say, I'm not going to be liable for negligence. They may be indemnity, which says, Mr. Tenant, if you do something and I get sued for it, you're going to have to pay my costs and any damages, and limitation of liability. Those are commonly in contracts. Understand that under Missouri law, to be enforceable, they must be conspicuous, which means they must stand out against the background of other terms and conditions in the contract. Missouri does not want you burying things like this in the boilerplate of the contract. So that has to be seen. Now, it doesn't say it has to be in bold. Some people put them in all caps. Some people put a big heading on it, like this one does. Some people underline it. There are all kinds of ways you can make things conspicuous, but they must be conspicuous. And so you're going to have to make sure that whatever you're doing electronically and whatever the tenant is seeing on the screen where he or she is contemplating this contract, that these things are conspicuous. And so that's something to remember too. The other thing to remember is the Service Member Civil Relief Act. And you may remember this is the act that says that if a military person is on active military duty or within 90 days thereafter, and they are in default, you as a self-storage owner may not have a lien sale unless you have either a court order or you have a waiver like the one you see here. Now, remember, if you're doing this electronically, there are a couple of tricks here. Number one, this waiver must be separate from the rental agreement. They must be in two different documents. Now, the waiver must refer back to the rental agreement, but they have to be in separate documents. So somehow on your screen, if you're going to do this electronically too, you're going to have to make sure that those are in separate documents and separately signed. Keep in mind too that under federal law, this document, the waiver must be in 12-point type. The waiver must be in 12-point type. So, and there's no exception in the Service Member Civil Relief Act for documents that are electronically entered. So you're going to have to make sure that whatever you're doing electronically complies with that as well, because if you sell property of a service member while they're on active military duty and this waiver is not good, not only do you have all of the other problems we discussed, but now nobody is your friend. If somebody's on active duty serving their country and you sell their stuff when you shouldn't, good luck, because it's not going to be very pleasant as you deal with all of this. So again, I would come back to Stanley the Bear telling you, look, nobody can comply with Missouri law except you. And if you're using an electronic format in this digital age, please make sure you do not forget to comply with the Missouri Self-Storage Act and the other acts we've talked about. So with that said, I'm going to take this off the screen, and I am open, and Shelley, for any questions people might have. I think we have a couple of minutes here, and I'd be happy to talk with you.
Thank you, Stan. That was that covered a lot. And thank you for that handout too. That was extremely helpful. I do have 3 or 4 questions that came in.
Okay.
This one's from Jessica McLallen. How long do I wait after the second default notice if stored items will be disposed of, thrown away instead of sold? And an ad does not need to be published to throw away items, does it?
I don't believe so. The ad talks about if you're having a sale, and the statute talks about this being otherwise disposed of, meaning other than a sale. So I think, no, you don't have to publish an ad. I do think it's good to at least notify the tenant that, you're in default, second notice of default, there's nothing here of value in our opinion, and we're going to dispose of it. And I would just say, give the tenant a reasonable period of time after notifying them of that before you rush off to the dumpster.
Yeah. Okay. Yes, I guess it's the more communication, the better, as far as that
and
goes.
you never get in trouble under the Missouri Self-Storage Missouri Self-Storage Act by giving too much information to the tenant. You get in trouble by not giving enough or giving it at the right time. So yes, you can, if you want to send a letter to the tenant every day they're in default until you get to the lien sale, that's up to you. It's not required, but you can.
Yeah. Okay. This one comes in from Chad Reisinger. Do I have to sell the unit contents after default? Can I keep the items in the unit after default? Would I need to publish an ad if I'm not selling the unit?
No, you have to if you're going to, basically I ran through a number of things you can do. If you've got a tenant in default, you can let them stay in the unit and sue them for what they owe you. You can terminate the contract and tell them to get out. You can, if the stuff has no commercial value, you can toss it. And I suppose if you want somebody else's junk, you can keep it. But the bottom line is, if it has any commercial value at all, you can't do that.
Right.
And then, of course, if it's a vehicle or a watercraft and rent's been unpaid for 60 days, then you can, then you can have it towed off your lot and it's not your problem anymore. But generally speaking, if you've got somebody in default, you've got to have a lien sale to get rid of that property. You can't just say, hey, this is really great stuff, I'm going to take it home with me.
Right.
Now, that's a really interesting question. Can an owner bid at his own lien sale? The answer to that is yes, as long as it's a public sale, as long as it's like an auction, okay? And even so, I think it's a good idea to tell people, hey, I am the occupant, I'm the operator rather, I'm going to reserve the right to bid at the sale if I want to.
Right. And while we're talking about that, how many bidders do you have to have for it to be considered an actual public auction?
Well, that's a good question. And I'll tell you, I don't know of a specific number, but I think arguably you could say, that's a really good question I never thought about. I think if you've done all the publications you need, you have the notice, you have an auction, and you've got a couple of bidders who show up, that's fine. I think you at least have the potential for an auction to work the way it is supposed to, which is to reach the market price because you've got people bidding against each other. Now, if only one person showed up, little less that it's going to be okay, although you can do a private sale, which is to a specific individual if you want to, but I don't know. That's a really good question. I don't think I can quantify it for you. Again, it comes back to what's commercially reasonable. How would a merchant selling the goods in this unit reasonably sell them? That's kind of the way you determine that. And there is no clearly defined answer to that. But I would feel fairly comfortable if you've got a couple of people showing up, I think that would work.
Right. Right. Okay. We'll do two more. Got, does the lien sale advertisement have to include the name of the tenant, or will the unit number suffice?
Yeah,
Pretty common question.
it is a common question. Our statute doesn't require you to put the name in. And I've seen it done both ways, and I can make an argument both ways. I suspect if I ran one, I might. I like the unit number in there for sure. I like the name in there because that's one last opportunity to cut off the tenant who says, I didn't know anything about this. Well, it's in the newspaper. Your name was next to the unit.
Sure.
And I often see it's just the last name rather than the full name. And I think that's fine. But no, technically it's not required.
Okay. And we'll do one more. Okay. With electronic contracts, even giving the option to print or save, can we also go one step further and mail a completed copy just to cover all the bases? Or is this just an unnecessary step?
No, absolutely. That's a fine step to take if you want to. I think that's a great answer. Because also that gives you an opportunity to make sure all of those technical things that need to be in bold, things that have to be in 12-point type, things that have to be conspicuous. But that gives you just another way of making sure that the tenant can't claim, well, I didn't know any of that, or that's not what it looked like on the screen, or what have you.
Right.
Yeah, I think it's a good idea. Is it technically required? No, but I think it's a pretty good idea.
Yeah, I think it is too. Okay, we'll do one more and then we'll wrap it up. This one's coming from Bill Stouffer. Regarding signatures on rental agreements, should each page of the agreement be signed? I know a lot of times we see initials there.
Yeah, and that's fine. And that's an age-old question, because what happens if you sign the first page and you forget to initial the rest? Well, then there's an argument that clearly the tenant didn't see these because the initials aren't there, when really it was just overlooked. I think in my opinion, the best approach is to whatever the tenant signs, it has a reference. It's either self-contained, all of the terms are on the page that they're signing, or there's a reference. Oftentimes, in fact, our old carbonless forms used to do this. They would say there are additional terms on the back of which I am aware.
Mhm.
At least make it clear that when they're signing, they knew or should have known there were more terms to this thing than were just on the right above the signature, for example. So I like doing things like that to make sure that nobody can mistake the fact that there were 25 different provisions of this contract, not just the 6 that were above the signature page.
Sure. Let's do this one more. And I know I sent this over to you to last week. So this comes from Kim Kirschbaum. Does the Service Act include non-military EMTs, nurses, etc.?
Yes and no. So it's a very
Yeah.
In addition to what we think of as the uniformed services, the Army, the Navy, the Coast Guard, the Marine Corps, all of those, Air Force, all of those, the statute does make reference to the Public Health Service and
Yeah.
National Weather Service, something like that.
Mhm.
I don't have it in front of me. So those two are also considered uniformed services, believe it or not, of the federal government. So there may be people from the health service in uniform that are out dealing with issues, and they would be covered under the act. And if you happen to be a nurse in the Army, you're covered on active military duty. Or if you're an EMT in the Air Force, you're covered.
Right.
But if you're just my local EMT guy, no, I don't think it covers you. If you're a nurse at the local hospital, sorry, I don't think this protects you.
Okay. Thank you for clarifying that. We'll go ahead and wrap up. And if I've got these some other questions that we've got, but I'll try to get those answered either with Stan later today. Stan, thank you so much for being here. Hopefully we can post this on our website here in the next couple of days. People can go back and kind of review it, make sure everything is clear. And then also if any of our members or attendees didn't get the handout, please email me. It's sharris@mssoa.org, and I will send that over to you today. other than that, we just thank you so much, Sam, for being here. Thanks again to the storage group. This will be our last online educational opportunity for this year. So we will see everyone in the new year. Thanks again for joining us.
Thank you.
Thanks, Dan. Bye-bye.